Welcome to Kent Law School Summer of Law webinar series. Today we're going to look at how to read law in statute and cases. My name is Sheree Palmer. I am a Student Success Project Manager at Kent Law School, which means my job is to support students to raise potential, to raise their attainment, to meet their full potential. I also teach on stage 1 modules on the law degree, so you may come across me there. I'm also joined today by my colleague, Charleton.
Hello there. So my name's Charleton. I'm a lecturer at Kent Law School, and prior to that I was a criminal barrister. Some of you might have seen me in the criminal prosecution session.
Thank you, Laura. Okay, so why are we engaging with this topic? Why are we going to focus on statute and cases? Whether you choose to study with us at Kent Law School or anywhere else, it will be essential that you understand the importance of statutes and cases and how to read them. That will be a fundamental part of your course. We've chosen to show you how to read these and understand these through the lens of cyberbullying because it's a hugely topical issue. I should probably begin by saying it is also a very sensitive and can be a challenging issue, as is the subject of law itself. Should you choose to study law, you may well find yourself advising clients, and your role would be to help them navigate the legal process whilst maintaining your objectivity and professionalism. So that being said, the first thing we're going to do is I'm going to ask you a question, but I should say that throughout this we're going to be asking you to take part because we want to hear from you. So you can raise your hand, so you might want to have a play around so you know where that function is, and also to put your comments into the chat function. So just be reassured, nobody else can see what you've written apart from us, so you can say whatever you like, be anonymous. The main thing is we just want to hear your thoughts and see what you think. Okay, that being said, can I start off by asking, can you just raise your hand if either you have experienced cyberbullying or if you know someone who has?
So, wow, Sheree, I can see that many hands went up really quickly then, which is really interesting because it seems to suggest that this is a current and topical problem.
Mm-hmm. Okay, that's really interesting. I mean, that's a sad thing, but it goes to show just how current this issue is. In fact, it's such a topical issue that Catherine McKinnell MP, who's chair of a committee in the Houses of Parliament, she actually stated how dangerous it is, and particularly it's dangerous and it's burgeoning during lockdown when people have much more time to spend online. But Catherine McKinnell MP said online abuse is a silent menace. She went on to say with social distancing rules, people are spending ever more of their lives online. The importance of doing something about this issue before it causes more damage is greater than ever. If we don't take action soon, then there's a real risk that a whole new generation will be irretrievably exposed to and harmed by online abuse. So we're going to start. So that's the reason why we've chosen to use cyberbullying, because it is such a topical issue, because it's growing. So what we'd like to do as our starting point is think about how law is actually created. And we're going to do that by looking at the organs of the state. So the state comprises of 3 sections. So first of all, we have Parliament, the legislature, which create law, and Parliament is sovereign. Then we have the government, the executive, and it's their job to implement law. And finally, we have the judiciary or courts, and it's their job to interpret the law as laid down in legislation and to apply it as they believe Parliament intended. But the main thing to be aware of is that Parliament has unlimited legislative competence, so they can enact any law that they choose. So the next thing to think about is, how does the law actually come into being? And we're going to show you now the passage of a bill. So laws start off as bills, and a bill can begin in the House of Commons or the House of Lords, it doesn't matter which, but you can see there's quite a long, rigorous process, several readings, committee stage, and it finishes up with royal assent, which is essential. Now, the royal assent is actually kind of a technicality and a formality, and it hasn't been refused. The royal assent is agreement of the monarch, and that hasn't been refused since the 18th century and the reign of Queen Anne. But at the point that a bill, which can begin as a public bill, a private bill, or a hybrid bill, after passing through the readings, after getting royal assent, the point when it gets royal assent, it actually becomes law. It becomes a statute, also known as an Act of Parliament. And there'll be about 60 to 70 acts that will be passed per session. Now, Laura is now going to explain to you what is case law and the hierarchy of the courts. You can understand more about how the system works.
Thanks, Sheree. So Sheree has just been telling you about statute and the sovereignty of Parliament, meaning that Parliament is the supreme lawmaker in the United Kingdom, although that in itself is a statement that is subject to some challenge and debate that no doubt you will encounter as you continue in your studies of law. But effectively, if Parliament has spoken, then everyone has to apply the law that Parliament has made. So where do cases fit into the law-making process? Well, England and Wales is a common law jurisdiction, meaning that as well as statutory law made by and under the authority of Parliament, as Sheree has just described, law can also be made by judges, so judge-made law. The judge-made law is found in the judgments of the courts, commonly referred to as cases. But not every court can make law. Now, on the 30th of July, we have another webinar specifically on what different courts do. And so today I'm only going to touch upon the court hierarchy in summary to give you sufficient information to understand how to read judgments. But to find out more about the specific roles of the courts, do join us again at the end of July. So I suppose the primary function of courts is to administer the law, and that's probably what we think of when we think about courts. We think about courts hearing disputes, resolving them by applying the applicable law to the dispute. If you look at the bottom half of the diagram on the screen here, you'll see courts that are probably familiar to you: Magistrates' Court and Crown Court, also the County Court and the Family Courts. And these are examples of well, you could call these courts the lower courts, sometimes called courts of first instance. And that's because these are courts that hear disputes through trials and hearings and come to a decision where the parties have not been able to. So it might be a criminal allegation in the Magistrates' Court or Crown Court, maybe a claim for damages in the County Court from a car accident, let's say, maybe a family dispute, perhaps dividing up the property at the end of a marriage. Now, these cases, although incredibly important to the participants, are not reported in any official capacity. Maybe a newspaper will run a story about the cases. But that's because the decisions that are taken are really only applicable to the parties. And so these courts are administering the law, applying the law that Parliament has created through the process Sheree just explained, or applying precedent from higher courts, which I'll tell you about now. So that's the top half of the diagram. And this shows what you could call the appellate courts, the courts that hear appeals. That said, as you'll probably find out in the session towards the end of July, some of the lower courts also have a appellate function. They also hear appeals. But broadly speaking, the higher courts are recognised as the High Court there in the middle of the slide, above it the Court of Appeal, and then above it the Supreme Court. So rather than making factual decisions about disputes, these courts are really determining legal arguments. So a case will only reach these courts if they first of all it's been heard in a lower court, and then it's appealed upwards through this court hierarchy on the slide. Now, in determining these legal arguments, the courts may end up making law, either because they're interpreting the words that Parliament has chosen to put in the statutes in order to apply those words to a sort of real life situation, or because they're filling in the gaps where Parliament has not legislated. So if Parliament has not made a specific law, the courts can develop the law in that area. And in making these decisions, these higher courts are creating precedents. So meaning that it's not just the parties who have appealed the case who will be for whom the decision is important, but also it will affect later cases to be heard in the lower courts, because the outcome of the appeal case will set a precedent that the lower courts have to follow. So, and you can see that, hence the diagram, the hierarchy there. So the highest court, the Supreme Court, sets a precedent for all courts below it, for example. Why do we have a look at judgments? Just briefly before I hand back to Sheree, you know, why do law students, practitioners, academics read cases? Well, two main reasons then. Firstly, because from those higher courts, they set a precedent, and that precedent, you know, following what's gone before, might be binding on the outcome of a later case. In other words, that it has to be followed. If not binding, perhaps it will be persuasive, it will be useful, it will persuade the court how to act. And when I say the judgment is binding, what we're really looking for in the judgment, and we'll have a look at a judgment later, is what's called the ratio decidendi. So the actual kind of outcome of a case, you know, who wins, who loses, who's found guilty, not guilty, that's not the binding bit, but it's how the court got to that decision. It's the reasoning which sets the precedent for a later case. That's called the ratio decidendi. We have some Latin still left in law, or much less than it used to be though. And then we distinguish that from basically everything said in passing, everything else. That's known as obiter. So we're reading judgments because we're really trying to ascertain the ratio of the judgment to apply it to the later cases. And the other reason then is because the courts are interpreting the statutes that Parliament has created, as Sheree explained. And of course, statutes are just words, and words, language, you could say, is an imperfect tool, in that, you know, words can be ambiguous, or perhaps situations arise that might not have been specifically envisaged by Parliament. And so the courts use certain techniques, certain ways of effectively trying to work out what did Parliament intend, because they're supreme, Parliament is supreme, they've passed the law, so the courts need to try to apply it in the way they believe Parliament intended. And so there's different rules of construction. You'll learn about those in your studies if you choose to study law, like the literal rule, where you take the literal meaning of the words, or the mischief rule, where you work out, well, what is the act trying to sort out, and then apply it in that way. So that's why you would be reading a judgment. And Sheree and I will show you a statute and then a judgment to sort of highlight the key aspects of what you're looking for in those sources. And the examples that we're going to use connect to the topic of cyberbullying, as Sheree said. So before we show you the examples, we wanted you to have a think about cyberbullying, didn't we, Sheree? Oh, you're on mute, Sheree.
Okay, that's better. You can hear me now. Right, thank you. So we're going to start off by asking you, when you think of cyberbullying, and just put this in the chat box. So when you think of cyberbullying, what do you take it to mean? So could you just quickly write down your definition or explanation in the chat box? So how would you define cyberbullying? And then Laura's going to summarize some of the ideas that you come up with.
I did it that time as well. We've already got some really excellent considered thoughts coming through. In fact, so many, it's hard to keep a pace with them. But let me just summarize for you. Online trolling is one example, mean words, online harassment. So very much the theme of the method of communicating seems to be online, harassment, ongoing, repeated targeting, bullying through the online medium are examples, fantastic examples, intimidation through the internet, attacking sort of virtually, continuous harassment. That's a flavour of the responses that we're getting there, Sheree.
Yeah, great. Those are, yeah, absolutely. All of those different actions are encompassed, and there may be others that we haven't thought of. But I'm going to give you a definition from the Law Commission because they know a lot more than I do. So they've defined cyberbullying as the use of the internet, the use of internet-enabled forms of communication to bully a person, typically by sending messages of an intimidating or threatening nature. So some of those ideas you just shared, of course, come perfectly under that. So the next question we'd like to ask is, what do you think is the harm that's caused by cyberbullying? And again, can you just pop your answers into the chat box? So what is the harm that's caused by cyberbullying? What are the consequences?
Yeah, and again, straight away, what fantastic participants we've got today, as ever. Immediate responses, you know, from ranging from psychological harm, anxiety, suicide or suicidal thoughts, fear, causing low self-esteem, mental health, yeah, a massive impact on someone's mental health, can affect school life, work life, so kind of also perhaps even an economic impact on someone's life, depression, these kind of harms that are being mentioned.
Yeah, perfect. Okay, so as we can see, the extent of the consequences is quite wide. So it can impact on individuals, it can affect companies because with professional reputations. But one of the issues with cyberbullying is it's worse than traditional bullying in the sense that it can follow children home, so school children home, and they could be subject to it sort of 24 hours a day. So as you've mentioned, it can include things like stalking, unwanted emails, doxing, releasing personal information online, a whole category of different actions. So we've mentioned as well that it's psychological and physical, and cyberbullying is a contemporary and it's an evolving social problem. So something we're really interested in finding out, given this is a contemporary problem and it's burgeoning, how old do you think the laws are that are currently used to address cyberbullying? And just pop that into the chat box. So how old do you think the laws are that are currently used to address cyberbullying?
So we've got a wide range of responses: 10 years, 5 years, inadequate is one of the responses. That's very astute response. 20 years, 5 years, not as up to date as they should be. Also some older guesses. Sheree, tell us.
Okay, you might be really surprised to find out that actually the substantive law that is used to deal with this contemporary issue and address cyberbullying dates back to the Victorian period. It's a really archaic law. It dates back to 1861. So that's the reason why we've chosen to look at that specific statute, which is called the Offences Against the Person Act of 1861. So I'm just going to take you through the anatomy of this statute. This law is still the law that is used to deal with physical harm. And as we'll shortly see, it's been extended to include psychological harm, which wasn't included when the law was first created. So we can see as well the need for law to change and adapt. So looking at this statute, we can start off by looking at the short title right at the top, Offences Against the Person Act, and it tells us 1861, which is the year that this became law, became an Act of Parliament or a statute. So that's the starting point. Underneath that, we can see a citation, which gives us a year, and it also makes a chapter reference. So acts are numbered according to which the year they are passed in a specific year. So this act was the 100th act that was passed in 1861. And you'll notice as well, it says 24 and 25 Vict. So in this information here, it also tells us in which year of the current monarch's reign. So it's telling us that this law was passed in the 24th and this act was passed and came into force in the 24th and 25th years of the reign of Queen Victoria. That's an awfully long time ago. So you can begin to imagine some of the difficulties that might result from that. We didn't have online. There wasn't such a thing as online in the Victorian period. So we're now going to look a bit further down. One of the things you'll notice is there are lots of amendments and modifications. And that really shows us just how much laws change. So a law can be repealed, deleted, it can be amended. A statute may contain prohibitions, it may contain warning, things that you can't do, like to contain a schedule, a commencement date when the act actually comes into force, because the date the act is passed isn't necessarily the date the act comes into force. But what I'd like to look at with you, although many of these sections have been repealed, and we can see, so underneath the short title and the citation, there's the longer title where it says, an act to consolidate and amend the statute law of England and Ireland relating to offences against the person. So we can see it's some consolidation of previous statutes. Then we've got modifications. And you can see that many sections have been repealed because it's so old. But I want to show you 3 sections that are still in existence, which shows you the sort of hierarchy of offences relating to offences against the person. So let's start by having a look at section 47. Now, one of the things you'll see is that the lower the number, the more grievous or more severe the offence. So section 47 refers to assault occasioning actual bodily harm. And then so that will include things like, minor fractures, bruising, wounds, and it's then up to the courts to use the language within the legislation to decide on the severity of the offence. So if we now move to section 20, that's a more serious crime or offence, and the clue there is in the use of language. So it refers to grievous, meaning severe. So it's inflicting, wounding or inflicting grievous bodily harm. And it would be up to the court to determine whether that was an appropriate offence for a particular, that was an appropriate offence. If we now move to section 18, it becomes even more serious. And the clue is in the use of language. So the clue is in the mens rea or guilty mind of the defendant or defendants, because the prosecution would need to prove intent. So whereas section 20 simply requires proof of the defendant's intention or recklessness, so the reckless actions caused grievous bodily harm, to meet the requirements of section 18 offence, the prosecution has to be able to show that the defendant intended their actions, there was intent. So you can see there the hierarchy of offences. Another thing I want to draw your attention to, if we go back to section 47, you may also see a little purple lozenge. And that little purple lozenge says E plus W, and that stands for England and Wales. And what that tells us is that this section of the statute relates to the law in England and Wales. And in the paragraph below, we see another lozenge and it says NI, and that stands for Northern Ireland, which means that section only applies to Northern Ireland. So you can see that within an act, there may be modifications depending on the jurisdiction that it applies to. So I've shown you the short title, the citation, the long title. I've pointed out that there are sections which are numbered, and that a statute may contain a range of other features such as schedules, prohibitions, exemptions, and so on. We're now going to move on. Laura's going to take us through some cases so you can see how the Offences Against the Person Act of 1861, this archaic law, has actually been applied in real life cases.
Great, thanks, Sheree. So of course, you can imagine there are a number of cases arising out of a piece of legislation that is so old and yet still currently being used. But I wanted to show you this case today, the case of Ireland and Burstow, because it illustrates how the law, how the courts moved with societal changes to apply a very old piece of legislation to more recent modern problems. And it paves the way to deal with cyberbullying under this legislation also. So there's quite a few things to point out in a judgment, and if only I had longer, I could talk at length to you about it. So I've tried to show you the key features today. The first thing I wanted to point out then is this citation here. Now, if you recall, I mentioned that it's the higher courts that set precedents, and it's their cases that may get reported. Now, by reporting, what I mean is that an editor of a law report, so a publication that you have to purchase to access, may decide that the judgment is an important one that needs to be disseminated, that people need to know about it. And you can see why that could be the case, because we need to be able to find out the decisions that set precedents. So this is an example of a citation in a law report. With changes in modern technology, judgments are also now more freely available, and so you can access online more freely the judgments in cases. But I'll show you the difference between a law report and then a sort of a neutral judgment. Because the law report, the editors sort of add value, make our lives a little bit easier by helping us to understand the judgment. So there are a number of law reports available. This is just an example of one of them, and it will. And when you have a big important case like this one, several law reports will publish the judgment. That should be the same across all of the reports, but it's the content that's added with the judgment that differs. So next we've got the party names. So this case is Regina, the Crown against Ireland, and the Crown against Burstow. In fact, this is two completely separate cases. So they would have been in completely different Crown courts. Mr. Ireland was on trial, Mr. Burstow. Their trials occurred, or in fact, I think they ended up pleading guilty. And then they appealed their convictions, going up in the court hierarchy. That would be to the Court of Appeal. And then they appealed again up to the highest court, which I'll show you in a moment. At the time of this judgment was the House of Lords, but now from that diagram earlier, the Supreme Court. Now, but however, because both cases dealt with similar issues, their appeals were joined together. So there's one judgment here from the House of Lords, albeit they were two separate cases. So that happens sometimes, look out for that. So the court name is typically given. The House of Lords, as I said, previously would have been on the top of my court hierarchy. The Judicial Committee within the House of Lords was the highest court, now the Supreme Court. Underneath that, you typically find the names of the judges in the judgment. And you can see here we have 5 law lords. And so it's not just one judge who hears the cases. And what that means is that each of these judges has the right to give their own judgment. So don't assume when you go to a case that you might just be reading one judgment. Here we may have 5 different judgments. Now often, if in agreement, and particularly more recently, one judgment will be delivered on behalf of everyone. But if one of the judges disagrees with their colleagues and has come to a different conclusion, then they will deliver their own judgment. And so sometimes you have to read through all of the judgments to ascertain, well, what's the majority view here? Because that will be the decision of the court. The dates underneath are the dates that the legal argument was heard in front of the court, and then the date of the judgment. And these keywords here, the editor of this law report has chosen for us to help us when we're doing our research to highlight what this case is about. So you can see, if you've been looking whilst I've been talking, it's about the Offences Against the Person Act that Sheree has just shown us. Next, again, not the judgment yet, but the editor of the law report has summarised the facts for us. So the first case, Ireland, was about silent telephone calls to 3 different women that caused psychological damage. The second, Burstow, was also silent phone calls, in addition some menacing notes and photographs, and this caused severe depressive illness. What the editor has next done is that they have summarised the judgment in this particular case. So what decision did this court reach about these cases? And we'll see in a moment what they were needing to decide. I'm just going to scroll down, apologies, on the screen to the next key feature to point out. So this law report has summarised for us what happened in the court below this court. So the trial occurred, appeal to the Court of Appeal Criminal Division, summarising what the appeal was about. And in order to reach the highest court, now the Supreme Court, in criminal cases there has to be a point of general public importance to justify reaching the highest court. So in this particular case, it was whether the making of a series of silent phone calls can amount to an assault. Scrolling down then, this law report has summarised for us the arguments that the lawyers advanced in front of this court before they reached their judgment. So this is really useful, particularly if you're studying a particular topic. But remember, this is not yet the judgment. This is simply the arguments that were advanced in order to persuade the court. And then finally, we get to the judgment. So if you access the judgment only, this is what you'll have. Accessing it through a law report, you get the extra information. So in this particular case, the first judge indicated he agreed with his colleagues, and that was the sum of his judgment. The next judge similarly. Now the next judge, Lord Steyn, he had more to say. He delivered the main judgment. Obviously, I can't talk you through all of it, but what I want to highlight for you is that he's explaining that these men were charged under the Offences Against the Person Act that Sheree has shown us, and he summarised the offences again for us. And he's explaining that the issue here is whether psychological harm can be determined to be bodily harm. So the Act refers to actual bodily harm or grievous bodily harm. And when we think of bodily harm, we tend to think in the physical sense, cuts, bruises, wounds. The issue here is whether psychiatric illness can be capable of amounting to bodily harm. So he goes on in his judgment and he explains that there has been an earlier decision by the Court of Appeal. Remember, of course, the Court of Appeal is below this court, the House of Lords, now the Supreme Court. And in that case, Chan Fook, they said, yes, it was psychiatric injury. But of course, this court is above that court in the hierarchy, so they're not bound to follow that decision. They do not have to follow it. What does this judge say then about the issue? Well, he says, look, the court's role is to interpret the words that Parliament has used. And if we were being sort of very strict on that approach, we would have to think about what was in the minds of the legislators back in 1861. And he recognises that psychiatric injury was not in their minds. So I've tried to highlight, some keywords for you as I talk to you. But that the court need to approach these statutes with modern eyes. And so in that case, and given the advances in medicine and psychiatry and so on, he feels it appropriate to interpret bodily harm to include psychiatric harm also. Now he goes on to talk about other aspects of the case, of which sadly we don't have time to talk about today. But if you recall earlier, I was telling you about the ratio of a case, of a judgment. Why do we read these judgments? We need to find the ratio, which is the bit that binds later courts. And so this would be an example of something that we could determine to be the ratio of this case. That according to the case of Ireland and Burstow, bodily harm in the Offences Against the Person Act does include psychiatric harm. Scrolling down to finish then, that's 3 judges that we've talked about so far. The next judge here has a little bit to say, but effectively agrees with his colleagues, as does the final judge. And so at the very end, they all dismiss the decision. The outcome at the bottom there is that the appeals are dismissed. So these gentlemen were not successful in seeking to overturn their convictions. Now, as you can hopefully appreciate, so I'm just distracted by looking at the questions in the chat to see if I can help assisting as we go. How are dissenting judgments used is one of the questions. Well, it might be that although the judgment was dissenting on this particular issue, there might be a similar case that comes along with a slightly different issue, and the lawyer in that case might want to draw on the dissenting comments from this case as a way to advance an argument. For example, now those dissenting comments will only ever be persuasive, never binding, because it's the ratio, it's the majority that stands. And by dissenting, I mean disagreeing. So a judge who disagrees with the majority, that would be dissenting. So not all 5 judges need to agree with each other, but the majority rule is the outcome. So 3 out of 5, let's say, hence why you'll find courts tend to sit in odd numbers so that we have a majority. Now you can see how this case then, the court was dealing with something that was not envisaged in the Victorian times, You know, silent phone calls would not have been envisaged when the Offences Against the Person Act was legislated. Neither was psychiatric harm as bodily harm, but the court was able to interpret that language to include psychiatric harm through the medium of silent phone calls, and pave the way, therefore, for this legislation to similarly be used when society advanced to this more recent trend of cyberbullying. So, you know, where psychiatric harm is caused through the kind of behaviours that you discussed earlier. Of course, the limit on this is that it does have to be a recognised psychiatric injury. And as we said, the different harms from cyberbullying may not always amount to a recognised psychiatric injury, and yet still be very distressing for those involved. So Sheree, how have the courts and the prosecution dealt with cyberbullying with other legislation?
Yeah, so we started by looking at the Offences Against the Person Act, because that's an act that you're likely to engage with on the criminal law module. So criminal law is obviously a core module. But we can see that courts also, so they use pre-existing legislation to encompass behaviours that weren't covered or anticipated at the time the legislation was drafted or and created. And because of societal changes and advances in technology, we need the law to adapt. So you've shown that the law has developed regarding such behaviours, but there are newer examples of legislation that can also be used to address cyberbullying. So we've had the Malicious Communications Act of 1988, the Protection from Harassment Act of 1997, the Communications Act of 2003, amongst some others. So these are there are some pieces of legislation that specifically encompass online communications and which have been used to criminalise them. So what we'd like to do now is to show you some examples from those pieces of legislation, and then we're going to give you some factual scenarios, because we'd like you to have the chance to consider whether you think this new legislation fills all the gaps that are left by the Offences Against the Person Act. And we want you to determine whether you think this legislation could be interpreted, so that's the role of the courts, to interpret what they think Parliament was saying in the legislation. So do these factual scenarios encompass the legislation that we've shown you? So we're going to start off by looking at the Malicious Communications Act 1988, and I'm going to just read it out to you. So under section 1, it's the offence of sending letters, etc., with an intent to cause distress or anxiety, and it covers any person who sends to another person a letter, electronic communication, or article of any description which conveys a message which is indecent or grossly offensive, a threat, or information which is false and known or believed to be false by the sender, or any article or electronic communication which is in whole or part of an indecent or grossly offensive nature. And a person is guilty of an offence if his purpose, and you'll notice it says his, although courts will interpret that more broadly, or one of his purposes in sending it is that it should, so far as falling within paragraphs that will be above, cause distress or anxiety to the recipient. I'm now going to give you some facts, a factual scenario, which is taken from a real case. And I'd like you to raise your hand if you think that the facts or the behaviour in this scenario would be criminalised under section 1 of the Malicious Communications Act I've just read to you. So here are the facts. Imagine a small village somewhere in England. It's got one little village, one little school, and it's staffed by female teachers, except for one male head teacher. The male teacher has been having an affair with a parent of a child at the school. The relationship breaks down, and the parent writes about the relationship in a blog post, falsely accusing the head teacher of being violent against her. She does not name him, but it is a small community, and she makes it very clear who she might be talking about. So our question for you is this: do the facts in this scenario fit into what is being criminalised under section 1 of the Malicious Communications Act? Just raise your hand if you think it is.
So we've got a slow and steady pace of people raising their hands, but not too many, Sheree. It's probably about, doing the rough maths, about a third perhaps of participants who are indicating that it would.
Great, fantastic. And the answer is it probably wouldn't be criminalised under the requirements of Section 1 of the Malicious Communications Act of 1988. And the reason is that a blog post is not sent to another person. So the Crown Prosecution Service, you've heard of them as CPS, have issued guidance, and they say that depending on the facts of the case, a social media communication, which is merely a blog or a comment that's posted on a website, may not suffice as sending to another. So prosecutors should consider the evidence that the communication was addressed either by name or in terms to a specific recipient, and also the likelihood that that specific recipient would receive it. For example, did the recipient have a Twitter or Facebook account? Were they part of a group that the person posting knew, the person knew that they were following? But it's interesting to think, if the scorned partner had sent the same content, for example via WhatsApp, to all the teachers, including the head teacher, that would seem to satisfy the requirements of Section 1. So I've just shown how there's a new example of legislation that was created in 1988 to deal with the offence of cyberbullying and online bullying, and there are still gaps. We're now going to show you another piece of legislation where blog posts would meet the requirements, and that's the Communications Act of 2003. So shall I read this one out?
Sure.
Okay, so Communications Act 2003, Section 127 deals with improper use of the public electronics communication network. So a person is guilty of an offence if he sends, by means of a public electronic communications network, a message or other matter that is grossly offensive or of an indecent, obscene or menacing character, or B, causes any such message or matter to be so sent.
So for this scenario, imagine a different scenario then, that someone's due to fly away on holiday in the next week's time or so. Obviously at the moment that seems unlikely, but at some point in the future that should be able to happen again. And let's say they notice that the airport is temporarily closed, and so they decide to use Twitter to sort of vent their frustrations at this. And they tweet a post, they send a tweet in their own name saying something along the lines of, "Oh crap, Gatwick Airport is closed. You've got a week to sort it out, otherwise I'm going to blow the airport sky high, exclamation mark, exclamation mark." So that was put on Twitter, the person's followers can see it. The airport wasn't particularly named or identified, or it wasn't sort of tagged, or whatever the correct terminology is in Twitter. Now, however, about a week later, someone at the airport spots the tweet, doesn't consider it a credible threat, doesn't think it's something that's going to be actioned, but protocol is that they pass it to the airport police. The airport police pass it to the local police. The man who sent the tweet is arrested, and he says, "Well, hang on, I was just joking. It was just a joke. Obviously, it was a joke. Just venting my anger." So a couple of questions arising from that scenario: tweet, threatening, blowing up the airport. First question then, taking into account Section 127 of the Communications Act, is putting a message on Twitter, is sending a tweet, not necessarily for anyone's particular attention, just those who follow you, is it sending a message by means of a public electronic communications network? Because that's what the offence requires. So would the definition of a public electronic communications network include Twitter? Hands up if you think yes, that would include Twitter.
Okay, so it looks as though the majority have got their hands up and they're saying yes, it does include Twitter. And in the chat as well, we've had a comment that yes, it's grossly offensive. Yeah.
Okay, great. So yes, you obviously one of the arguments, because this is based on a real case that was advanced on behalf of the person who sent the tweet, was, hang on a second, Twitter is owned by a private company, and so if it's a private company, it can't possibly be a public electronic communications network. But the court said, well, when you're interpreting what public electronic communications network means, we have to take into account that something like Twitter requires the internet, which is a public electronic communication network, to operate. And so, yes, Twitter would count for the purposes of this act. And I think Sheree said, someone said it was grossly offensive. So interesting to note that there's different ways of this offence being committed. Now, the prosecution in this particular case went under the menacing character. So they advanced their case because you can't really kind of have it all. You have to frame your case if you're prosecuting as to which part of the legislation you say is applicable. So they said it was menacing to be threatening to blow up the airport. So hands up, was this tweet found to be menacing, do you think? If you interpret the word menacing and you take into account the tweet that I described, hands up if you think, yes, this was a menacing tweet.
Okay, I'm just doing a quick count, and again, it looks as though the majority are saying it was a menacing tweet. Yeah.
Okay. Well, sadly, that would not be correct on this occasion. But why? Why did the court say this wasn't a menacing tweet? Well, the court had to interpret the word menacing because Parliament has not interpreted it in the Communications Act of 2003. They haven't defined it, sorry. And so the court had to determine what it means. And in so doing, they said that something that was sent as a joke and more importantly was received as a joke. So the person receiving the message, or at least the person who could be expected to receive the message, if they would brush it aside as a joke or as banter, which indeed the airport official, when they did see the tweet, did so, then it would be a contradiction to describe it as menacing in character. So interesting here, firstly, that the court, another example of the court needing to give an interpretation to words in statute where they're not specifically defined. Also interesting that whereas the previous offence that Sheree showed us, I don't know if I can just click onto that, required the message to be sent to another, and that the intent when sending it was to cause distress or anxiety. For this offence, no sending as such is required, hence why something in a blog could be picked up by this offence. But sent in a jokily fashion and accepted as a joke, not menacing character. Sheree, do you want to tell us, as we begin to come to the end of the session, how we approach matters of interpretation and topics like cyberbullying at Kent Law School as a critical law school?
Yeah, so I should mention that Kent Law School is hugely proud to be a critical law school. And what that means is we encourage our students to develop independent thought. So not to look at the law as black letter law, but to look at law in terms of a wider social context. So we develop our students' independent thinking and skills. So what does that mean in practice? Well, that means when we're sort of approaching an issue such as cyberbullying and thinking about the existing law, we'd be thinking about gaps in the existing legislation, overlaps, the consequences of consolidation. We'd also be considering conflicts. So, for example, is there a conflict with, if we bring in additional laws, is there a conflict with freedom of speech as laid down under Article 10 of the European Convention of Human Rights? So are we restricting people's freedom to express their opinions? Also, if we bring in more restrictions through legislation, are we increasing what's known as cancel culture? So there's a movement where if people express views that are seen as being unpopular or not in line with mainstream thinking, they may be disinvited, for example, from giving speeches or restricted from using certain forms of communication. We've also seen as well that there is already some self-regulation. So Facebook and Twitter, for example, have issued warnings against the messages posted by President Donald Trump in America. So we can see there's some kind of regulation there. But it's worth bearing in mind, we want to maintain freedom of expression. But at what point does something tip from just being someone's opinion to, for example, it constituting a hate crime? So when is something just someone's opinion, and when does it constitute another offence, for example, a hate crime? So another question to consider is, whose duty is it to deal with cyberbullying? Is it the duty of law? Can law address this in its entirety, this issue? Or should we be looking for greater regulation, self-regulation from technological companies and social media companies? Is it the role of parents to educate their children and offspring? So whose duty is it to deal with cyberbullying? Something else to think about. So moving on from that, we're now going to move closer towards the finish with 3 things for you to take away from the session. Over to you, Laura.
Actually, yes. So we've covered in the time together quite a lot of different concepts today, and really the part of what we're covering is quite a practical skill, looking at statute, looking at case law. It's something that you will develop over time, the skill of doing it. But we wanted to summarise the sort of 3 key messages to take away from today. Firstly, then, the first thing to take away from today's session is really about having the confidence to handle these 2 main sources of law in this jurisdiction, so legislation, the statutes, and case law. We've shown you some examples of these instruments, and we've tried to sort of point out the key features that will typically be present in many other examples of statutes and judgments also. The more opportunity that you have to use these sources, the more familiar you'll become with them, and the easier it will become also. Before we leave you, we'll show you a slide with some sort of additional resources that might be useful if you're interested in pursuing this further. And there's a link to the legislation.gov website, which is what we use to show you the Offences Against the Person Act, for example. So you can use that. It's a free resource to use to have a look at other legislation that interests you. If this is something that's new to you, clearly some of you may well have had experience already. So when approaching both of these sources, when thinking about reading them, to have the confidence to utilise these, think about why it is you're looking at the resource, the statute or the case. Are you reading just for interest? Is it to gain familiarity? Or is it because you want to ascertain a particular rule or requirement or a right that the legislation establishes? Or is it because you want to find out the principle that a case establishes, the precedent that it sets and that others will be subject to? So that's our first key point, to have confidence in using these 2 resources. Second point to take away from today's session is about the interaction between these 2 different sources of law. So you remember that Sheree mentioned the concept of the sovereignty of Parliament, meaning that if Parliament has legislated, then the courts must apply their legislation to the disputes in front of them. If there is room for interpretation, and we've already seen just through a couple of examples today that all of these words are subject to interpretation, then the courts, the higher courts, the Supreme Court, the Court of Appeal below it, the High Court below that, can interpret the legislation or indeed develop the law themselves through that doctrine of precedent that I was introducing to you today, the common law. Someone asked in the chat function, why is it that the monarch has to give their assent to the legislation, which Sheree mentioned? And that's really harks back to convention. We have to go back historically, and that's something that you may have the opportunity to explore on a degree. The sort of convention that the monarch has bowed to her parliament, because parliament is the more representative body compared to the monarch. So convention dictates. You'll see that well, in fact, the next webinar is about public law, and you may well have a discussion about the Constitution, and part of our Constitution is made up of these conventions, these traditions, these things that have built up over time, and that would be an example of one. So that's the second point, the interaction between the two sources. Third point to take away from today's session is really to appreciate that the law is not static. The common law system is responsive to societal change. This response might take the form of interpreting existing legislation, statutes, acts of parliament to encompass the changes as far as it's possible to do so. So advances in technology, for example, as we've seen with the cyberbullying, you know, going from physically hurting someone to perhaps sending messages through the mail service to perhaps telephoning to now being online. Or it might take the form of, you know, enacting and establishing new laws to try to keep a pace with societal changes in attitudes and behaviours, like the Communications Act of 2003. So the law evolves and builds on what has gone before, so it's not static in nature. That's the third point to take away. And Sheree, if you'd like to tell people about some additional resources.
Oh, yeah, hopefully we've stimulated your interest in the subject. So if you're now thinking, where do I go to read, watch, practice or learn more? Here's a slide which shows you some useful starting points. Laura mentioned legislation.org.uk, where you can find all government statute and acts. And also the Law Commission report from 2018 is worth having a look at. What I'd also like to draw your attention to is our next Summer of Law webinar on Thursday the 16th of July, which Laura just mentioned, and the topic of that is what is public law. So you can join our experts and they're going to explore the work of public lawyers and engaging with the UK Constitution. So do register if you're interested in that. So it just remains for me to say on behalf of myself and Laura, thank you so much for joining us. It's been great to have you with us. It's been really interesting as well to have a look at your comments and get your feedback on some of these areas. We hope you found that interesting and stimulating, and we really look forward to seeing many of you join us in the new term. Thank you so much. Have a good rest of the day. Goodbye.
Bye.
Bye.